So, the Supreme Court just handed down a 9-0 unanimous decision that's going to shake up constitutional law across the entire country. When all 9 justices agree on something, you know it's a big deal. So, if you haven't subscribed to this channel yet, go ahead and hit that subscribe button right now because we need to talk about what this means for every single American. The constitutional question that split America. We're talking about a Supreme Court case that addressed one of the most fundamental questions in constitutional law. And to understand why this matters so much, you need to know what was happening across the country before this ruling came down. Different federal courts were applying completely different standards to the exact same constitutional issue. In the Fifth Circuit, which covers Texas, Louisiana, and Mississippi, judges were using one approach. Meanwhile, in the Ninth Circuit covering the West Coast, they were using an entirely different test. And the Third Circuit in the Northeast had yet another interpretation. This meant that your constitutional rights literally depended on your zip code. Someone in California had stronger protections than someone in Texas facing the identical situation. And we're not talking about minor procedural differences here. We're talking about fundamental rights that are supposed to be guaranteed equally to all Americans under the Constitution. This disparity created a system where justice wasn't blind, it was geographic. The statistics show just how bad this problem had gotten. Between 2018 and 2023, federal appellate courts issued over 240 published opinions on this specific constitutional question, and they disagreed with each other in approximately 60% of those cases. That means more than half the time, courts couldn't even agree on how to analyze the same issue. Lawyers representing clients in these cases were essentially rolling the dice, hoping their case would be heard in a favorable circuit rather than an unfavorable one. But here's what makes this even more interesting. The federal government itself was taking different positions depending on which court it was arguing in because it knew different circuits had different rules. The case that changed everything. The case that finally forced the Supreme Court to step in involved a situation that on the surface seemed relatively ordinary, but the circumstances surrounding it raised profound constitutional questions that the court could no longer ignore. What happened was this. An individual was going about their daily activities when they encountered law enforcement under circumstances that should have been routine. The initial interaction was unremarkable. There was no immediate threat, no dangerous criminal activity, nothing that would suggest what was about to unfold. But then the situation escalated rapidly. The individual made a decision to leave the scene, which triggered a response from the officer involved. What the officer did next became the central focus of years of litigation. The officer made a split-second choice that resulted in the use of force, and that force had permanent consequences. When you look at the timeline of events, the entire incident from start to finish lasted less than 30 seconds. This brief moment would spark a constitutional battle that reached the nation's highest court. What made this case different from hundreds of similar incidents that happen across the country is what happened in the legal proceedings afterward. The family of the individual filed a federal lawsuit alleging that constitutional rights had been violated. They argued that the force used was excessive and unreasonable under the circumstances. But here's where things got complicated. The lower court didn't even look at all the facts. Why lower courts got it so wrong? The legal doctrine that the lower court applied in this case was called the moment of threat rule. And understanding this rule is critical to understanding why the Supreme Court ultimately stepped in. Essentially, this rule said that when analyzing whether force was reasonable, courts should only look at the precise instant when the force was used. Everything that happened in the seconds, minutes, or even moments before was treated as irrelevant. The officer's decisions leading up to that moment didn't matter. The tactical choices made didn't matter. The opportunities to de-escalate didn't matter. Judges in the Fifth Circuit had been applying this rule for years, and it created some absurd results. In one case, an officer created a dangerous situation through reckless decisions. But because at the final moment there was a perceived threat, the force was deemed reasonable. In another case, an officer had multiple chances to use less aggressive tactics, but chose not to. Yet, the court said those earlier choices were irrelevant. This approach essentially rewarded poor tactical decisions and discouraged proper police training. Legal scholars were writing scathing critiques of this approach. Professor Seth Stoughton from the University of South Carolina School of Law published research showing that this rule was inconsistent with how police training actually works. Here's the question you need to ask yourself. If someone makes a series of unreasonable choices that create a dangerous situation, should they be allowed to claim self-defense when that danger materializes? The road to the Supreme Court. Getting a case to the Supreme Court isn't easy. The court receives over 7,000 petitions for review every year and accepts fewer than 100 of them. That's about a 1.4% acceptance rate. So, what made this case different? Why did the Supreme Court decide this was the one they needed to hear? The answer lies in what's called a circuit split. When different federal appeals courts are applying different rules to the same constitutional question, the Supreme Court pays attention. The petition for certiorari laid out the scope of the problem in stark terms. It showed that the Fifth Circuit's moment of threat rule was in direct conflict with how the Second, Third, Fourth, Sixth, Ninth, 10th, and 11th circuits were analyzing these cases. Those other circuits all used what's called a totality of circumstances approach, looking at the entire sequence of events. The legal chaos was undeniable, and someone's constitutional rights shouldn't depend on which federal building they walk into. The Supreme Court granted certiorari in June, signaling they were ready to resolve this split once and for all. Both sides filed extensive briefs, and numerous organizations filed amicus curiae briefs as friends of the court. But nobody expected what came next. The stunning unanimous decision. When the Supreme Court issued its decision, the first thing that jumped out was the vote count, 9-0. In today's polarized political climate, unanimous Supreme Court decisions are increasingly rare. During the October 2022 term, only about 29% of cases were decided unanimously. The fact that all 9 justices agreed on this outcome sent a powerful message. This wasn't a close call. This wasn't a situation where conservative justices lined up on one side and liberal justices on the other. Justice Sonia Sotomayor wrote the opinion for the court, and her analysis was methodical and comprehensive. She began by examining the text and history of the Fourth Amendment, which protects against unreasonable searches and seizures. The framers of the Constitution, she explained, understood reasonableness to be a contextual inquiry. When the Fourth Amendment says government action must be reasonable, it means courts must look at all relevant circumstances, not just an isolated moment. The historical record was clear, and the Fifth Circuit had ignored it. The court then turned to its own precedents. In case after case going back decades, the Supreme Court had emphasized that Fourth Amendment analysis requires examining the totality of circumstances. The court cited Tennessee v. Garner from 1985, Graham v. Connor from 1989, and multiple other cases all saying the same thing. Context matters. You cannot evaluate the reasonableness of government action by ignoring the events that led up to it. What made the opinion particularly powerful was its practicality. Justice Sotomayor explained that the moment of threat rule doesn't just fail as a matter of constitutional law. It also doesn't make sense as a matter of police practice. What this means for pending cases nationwide the immediate impact of this Supreme Court ruling cannot be overstated. There are currently hundreds of cases pending in federal courts across the country that involve similar questions about the use of force and Fourth Amendment protections. Every single one of those cases must now be reconsidered in light of this unanimous decision. Courts that were applying the narrow moment of threat rule will have to go back and look at the full context of what happened. In the Fifth Circuit alone, legal researchers have identified at least 47 active cases that will be directly affected by this ruling. These are cases where individuals or their families sued claiming excessive force, and the courts applied the now rejected moment of threat analysis. Those plaintiffs now have a second chance. Their cases will be remanded back to lower courts with instructions to apply the correct totality of circumstances standard. The path to justice just got significantly wider for these families. Beyond just pending federal cases, this ruling also affects how law enforcement agencies train their officers going forward. Police departments across the country are going to have to update their use of force policies to align with this Supreme Court decision. Training curricula will need to emphasize that officers can be held accountable not just for the final moment when force is used, but for the tactical decisions and risk assessment choices they make leading up to that moment. So, here's what you need to consider. If courts can now look at an officer's entire course of conduct, not just the final second, how does that change accountability? The dissenting opinions that weren't. One of the most remarkable aspects of this case is what didn't happen. There were no dissenting opinions. There were no concurring opinions arguing for a different rationale. There wasn't even a concurrence agreeing with the result, but disagreeing with the reasoning. All 9 justices signed onto Justice Sotomayor's opinion without reservation. In Supreme Court terms, that's about as strong a statement as you can get. This is particularly significant when you consider the ideological diversity of the current court. You have justices appointed by Republican presidents and Democratic presidents. You have originalists and living constitutionalists. You have justices with prosecutorial backgrounds and justices who spent their careers representing criminal defendants. And yet on this question there was complete agreement. The Fourth Amendment requires a totality of circumstances analysis. Period. The unanimity sent a clear signal that the Fifth Circuit had crossed a line that even the most law enforcement-friendly justices couldn't defend. Legal historians are already noting that this kind of unanimity on a major constitutional question is relatively rare in recent Supreme Court history. During the Warren Court era in the 1960s, you saw more frequent unanimity on civil rights issues. But in the modern era, especially on questions involving law enforcement and constitutional rights, the court is often divided. How this reshapes constitutional law. The implications of this decision extend far beyond just excessive force cases. The Supreme Court's reasoning about how to analyze Fourth Amendment reasonableness applies to a wide range of constitutional questions. Anytime a court is evaluating whether government action was reasonable under the Fourth Amendment, it must now look at the totality of circumstances. That includes not just use of force cases, but also searches, seizures, stops, arrests, and investigatory detentions. This has already started to affect how courts analyze other types of Fourth Amendment cases. In search and seizure cases, for example, courts now must consider the entire sequence of events leading up to a search, not just whether there was probable cause at the precise moment the search occurred. If officers took unreasonable steps that created exigent circumstances, those steps are now relevant to the constitutional analysis. The ripple effects are being felt across multiple areas of criminal procedure and civil rights law. Scholars are also examining whether this reasoning might extend to other constitutional provisions beyond the Fourth Amendment. The Fifth Amendment's Due Process Clause, for instance, also uses the word reasonable in certain contexts. The Eighth Amendment prohibits cruel and unusual punishment, which requires contextual analysis. Whenever constitutional text requires an evaluation of reasonableness or propriety, the logic of this Supreme Court decision suggests courts must look at the full picture. This could fundamentally reshape how constitutional violations are analyzed across multiple amendments and legal doctrines. The decision also reinforces a fundamental principle of constitutional interpretation. Text and history matter. The court's commitment to originalist methodology combined with practical police standards created a framework that appealed to justices across the ideological spectrum. What happens next and why you should care? Looking forward, the most important question is how lower courts will actually implement this Supreme Court ruling in practice. The court has established the correct legal standard that application always requires judgment. Different judges may still reach different conclusions about whether force was reasonable under the totality of circumstances, even though they're now all using the same analytical framework. The facts of each case matter enormously. We're also going to see law enforcement agencies grappling with what this decision means for their policies and training. Progressive police departments that already emphasize de-escalation and tactical decision-making will find this ruling reinforces their approach. But departments that trained officers to focus primarily on split-second threat assessment will need to adjust. The Supreme Court has essentially said that good tactics and good constitutional compliance go hand in hand, and departments ignoring this message do so at their own legal peril. For ordinary citizens, This ruling matters because it affects how your constitutional rights are protected when you interact with law enforcement. The Fourth Amendment isn't just an abstract legal doctrine. It's a real protection that governs when police can stop you, search you, arrest you, or use force against you. The Supreme Court has now made clear that your rights must be evaluated fairly, taking into account everything that happened, not just a frozen moment in time. This represents a significant shift toward accountability and could potentially save lives by incentivizing better tactical decision making by officers. So, here's the final question. Now that the Supreme Court has spoken unanimously, will this actually change outcomes in cases? Or will officers still find ways to justify questionable uses of force? So, that's the breakdown of this massive 9-0 Supreme Court decision and what it means for constitutional rights nationwide. If you found this breakdown helpful, make sure to hit that like button and drop a comment with your thoughts on this ruling. And don't forget to subscribe so you never miss updates on major legal cases like this one. Thanks for watching.